You're listening to Audiology. Support this channel by becoming a member and be sure to submit your requests for topics in the comments below. The Posse Comitatus Act, signed into law by President Rutherford B. Hayes on the 18th of June 1878, sets boundaries on how the federal government can use military forces to carry out domestic policies in the United States. This law, which was initially part of an Army funding bill that came after the Reconstruction era, has seen updates over the years, including in 1956, 1981, and 2021. At first, the act was strictly about the U.S. Army, but in 1956 it was expanded to include the U.S. Air Force. Then in 2021, through the National Defense Authorization Act for fiscal year 2022, it was broadened even further to encompass the U.S. Navy, Marine Corps, and Space Force. However, this act doesn't stop state National Guard units, whether they're from the Army or the Air Force, from performing law enforcement duties within their own state or a neighboring one if they're invited by the governor. Also, the U.S. Coast Guard, which falls under the Department of Homeland Security, isn't affected by this law because besides being a military force, it has the role of enforcing maritime law. The name Posse Comitatus itself is derived from a legal principle, allowing a sheriff or other law officers to form a posse by enlisting the help of able-bodied citizens to maintain peace. Back in 1879, a piece of legislation known as Section 15 of the Army Appropriations Bill, with the full reference at 20 statutes at large, 152, was created. This was a significant move aimed at banning the U.S. Army from occupying the southern states that had previously formed the Confederacy during the 12-year period of Reconstruction following the Civil War. Under the U.S. Constitution, it's up to each state to oversee its own elections, keep the peace, ensure elections run smoothly, and handle any illegal activities. This responsibility falls under the state's police powers, which are essential for maintaining law and order, whether in a federal system or a centralized one. However, the situation was a bit tricky in the former Confederate states, where violent paramilitary groups tried to weaken African American political influence and restore white Democratic Party dominance. Despite initial federal backing for African Americans, that support faded over time. The contentious 1876 presidential election and the resulting Compromise of 1877 saw lawmakers from these states return to Congress, where they focused on preventing federal oversight in their regions. This push gained momentum when President Hayes used federal troops to quash the Great Railroad Strike of 1877, paving the way for what's known as the Posse Comitatus Act. Initially, this act applied just to the Army, but when the Air Force was recognized as its own branch in the mid-20th century, it too was included under the Act's provisions in 1956. The Navy and Marine Corps were effectively bound by the same rules through Defense Department guidelines until formally added to the Act in 2021. The Space Force, created in 2020, was also added that year. The Coast Guard, despite being one of the 6 armed services, isn't covered by the Act, given its unique law enforcement role on the seas. This service's precursor, the Revenue Cutter Service, existed mainly for customs enforcement under the Treasury Department before it became the modern Coast Guard in 1915, gaining military status and law enforcement authority. During the 1950s, President Eisenhower found a way around the Posse Comitatus Act to send troops to Little Rock, Arkansas, for the 1957 school desegregation crisis. This action was in response to resistance from the state's governor against the Supreme Court's landmark Brown v. Board of Education decision, which declared segregated schools unconstitutional. This workaround was based on the Enforcement Acts, which allowed the use of military force to protect constitutional rights when local authorities failed to act. The George Floyd protests in Washington, D.C. in 2020 stirred up debate regarding the deployment of National Guard troops without President Trump officially invoking the Insurrection Act, even though he mentioned it as a possibility. The D.C. National Guard operates somewhat like a state militia, but isn't restricted by the Posse Comitatus Act because it's a federal body under presidential command. National Guard units from other states were also brought in to help, with some members deputized as police. This move was justified by referencing a law meant for training exercises, leading to criticism and proposed legislative changes to prevent such uses in the future. Lastly, in 2020, Representative Adam Schiff proposed an amendment to broaden the Posse Comitatus Act's reach to include the Navy, Marine Corps, and Space Force. This update was successfully integrated into the National Defense Authorization Act the following year. Here is a simplified explanation of the laws in question, which are about using military forces for law enforcement within the United States. The original rule, established by an act during the second session of the 45th Congress, specifies that from the moment the act was passed, it wouldn't be allowed to use any part of the United States Army as a posse comitatus, that is, to help enforce laws, unless the Constitution or another act of Congress explicitly permits it. Furthermore, no funds allocated by this act could be spent on employing troops in a way that breaches this rule. Anyone who deliberately goes against this rule could face a fine of up to $10,000 or imprisonment for up to 2 years, or potentially both. Moving forward to the language you'd find in our current legal documents, according to Title 18 of the U.S. Code, Section 1385, using any part of the Army, Navy, Marine Corps, Air Force, or the Space Force to enforce domestic laws, unless allowed by the Constitution or an act of Congress, is prohibited. Violating this can result in a fine, imprisonment for no more than 2 years or both. Also, within Title 10 of the United States Code, there's a law aimed at the Department of Defense. It mandates that the Secretary of Defense must set regulations to prevent military personnel from directly participating in law enforcement activities like searches, arrests, or seizures, unless another law authorizes their involvement. In essence, these laws make it clear that military forces are not to be used for domestic law enforcement, except in specific situations allowed by law, ensuring a clear separation between military functions and civilian law enforcement activities. In 2006, Congress made changes to the Insurrection Act within the 2007 Defense Authorization Bill, though these changes were rolled back in 2008. On September 26, 2006, President George W. Bush proposed that federal laws should be updated, allowing U.S. military forces to step in and help maintain order following significant emergencies, like natural disasters or terrorist attacks. These suggestions became part of the legislation known as the John Warner National Defense Authorization Act for fiscal year 2007, which President Bush signed into law on October 17, 2006. A key section of this act, labeled Use of the Armed Forces in Major Public Emergencies, essentially said that the President could deploy armed forces within the U.S. to help restore order and enforce laws in situations where, due to severe emergencies like natural disasters, terrorist acts, or other crises, local authorities could no longer ensure public safety. Specifically, it allowed for military intervention to quell violence, conspiracies, or any situation that severely hindered the enforcement of law, to the point where people's rights under the Constitution were being infringed upon. However, in 2008, all these modifications to the Insurrection Act were repealed, and the act was returned to its original wording. The initial aim of the Insurrection Act was to keep the use of presidential military power in check during uprisings or chaotic situations. There are a few exceptions to the rule where a specific act doesn't apply. Let's walk through these exceptions in a more understandable way. First off, when it comes to National Guard units, state defense forces, and naval militias, they're not covered by this act if they are acting under the authority of a state's governor. However, if the National Guard gets called to operate under federal direction, through a law referenced as 10 United States Code, Section 12406, then they become subject to this act because their control shifts from the governor to the president. Additionally, there's a provision under 32 United States Code, Section 502, subsection F, that allows the president to use the National Guard in law enforcement roles, even when they haven't been federally mobilized. Federal troops can also be used under the Insurrection Act, which has been invoked 23 times up to the year 1992. This is a notable exception to the rule. In situations involving serious threats such as the release of nuclear materials, the Attorney General has the authority, under 18 United States Code, Section 831, to ask the Secretary of Defense for emergency help. This help must come from personnel under the Department of Defense and must not harm the military's readiness. An important note is that this doesn't apply to the armed forces deploying nuclear materials themselves. When it comes to enforcing laws concerning dangerous weapons like biological, chemical, or other weapons of mass destruction, the Attorney General can request military assistance under 10 United States Code, Section 282, according to specific codes. 18 United States Code, Sections 175A, 229E, and 2332E. There's also a provision for the military to aid in protecting foreign diplomats and their families under laws cited as 18 United States Code, Sections 112, 1116, and 1201, where the Attorney General can request assistance from various agencies, including the military. In the event of a terrorist bombing, the military can provide help, particularly with explosive ordnance disposal, under 10 United States Code, Section 283. Lastly, under 10 United States Code, Section 284, the military is allowed to support law enforcement with surveillance, intelligence gathering, observation, and equipment in missions that might include drug interdiction or counter-terrorism efforts. An example given is the deployment of Delta Force soldiers from Fort Bragg during the 1987 Atlanta prison riots, where they helped in various capacities, including as sniper observer teams, communication support, medical aid, intelligence gathering, and explosive breaching assistance, all upon the request of the Federal Bureau of Investigation. The United States Coast Guard is a unique branch of the armed services because it has the authority to enforce federal law, despite primarily being under the Department of Homeland Security during peacetime. This ability remains, whether the Coast Guard is operating independently or as part of the United States Navy in times of war, without being restricted by the Posse Comitatus Act, which limits military involvement in law enforcement. In 1981, a law was enacted to clarify the form of military assistance to law enforcement agencies, particularly regarding the prevention of drugs from entering the United States. This law dictates that the military can assist with activities such as utilizing their equipment, sharing intelligence, and providing technological support to law enforcement, but it prohibits military personnel from directly engaging in activities like searches and arrests. For example, if the Navy is monitoring a vessel suspected of smuggling drugs, members of the Coast Guard's law enforcement detachments, not Navy personnel, would board the vessel and conduct any necessary arrests. The role of federal troops in the United States has progressed from maintaining order in the South following the Civil War to managing significant riots. The Posse Comitatus Act restricts active duty troops from executing law enforcement duties, yet there is debate about whether this restriction applies when troops are serving in advisory, support, or defense roles instead of directly engaging in law enforcement. An instance of this debate arose on March 10, 2009, after a shooting spree in Sampson, Alabama, when United States Army military police from Fort Rucker assisted with traffic control and secured the crime scene without any specific request from state officials or presidential authorization. This intervention was later determined to violate the Posse Comitatus Act, leading to administrative actions against several military members involved. Thanks for watching. Share your thoughts in the comments and subscribe for more content.